Tonight, we begin with a development that immigration attorneys had feared, immigrant advocacy groups had warned about, and millions of green card holders had desperately hoped would never come. A policy shift that unfolded not over years, but in weeks. Weeks that have left thousands scrambling. Weeks that have separated families. Weeks that have turned the American dream into an American nightmare. For countless immigrants who followed every rule, filed every form, and paid every fee. What the administration did this month crossed a line that immigration experts had hoped would hold. And when that line broke, immigrant communities did not hesitate. They responded with confusion, fear, and desperate calls to already overwhelmed immigration lawyers. For months now, there had been signals, not official announcements, not formal policy memos, just signals, that the government was preparing something unprecedented. The administration has been aggressive on immigration, yes, but they have been methodical in their aggression. Their moves have followed a certain pattern, a rhythm, almost a predictability. But what set off alarm bells in immigration law offices across America this month was that the pattern went silent. Experts who monitor visa bulletin updates and USCIS policy changes know the indicators. The unusual delays in processing times, the sudden increase in requests for evidence, the quiet reassignment of adjudication officers, the sudden freeze on certain case categories. All of that went quiet. And whenever this administration goes quiet on immigration, it means something is about to get loud. Early this month, immigration attorneys detected what they described as coordinated policy implementation, including 5 major rule changes that had not been enacted simultaneously in over 2 decades. These are the kinds of regulatory shifts that the government only deploys when they are signaling something very specific: deterrence, enforcement escalation, or fundamental restructuring of the immigration system. Observers didn't know which category this fell into, or whether it fell into all 3 at once. But what they did know was that the government was changing its entire posture on legal immigration. And when an administration shifts posture without explanation, even by small measures, every immigrant in America pays attention. The advisory issued by the American Immigration Lawyers Association tonight was not normal. It was not routine. It was not symbolic. It was urgent. Attorney after emergency consultation described the government's move as unprecedented, retroactive, and perhaps most importantly, immediately enforceable without the typical comment period. But policy changes only work if the affected population remains uninformed. Immigrant communities did not. In fact, their response today was among the most organized we've seen in modern immigration history. Here's what we know. Within 72 hours of the first rule taking effect, advocacy organizations filed emergency petitions. These weren't the standard legal challenges. These were coordinated, multi-state federal court filings, legal tools that immigration advocates only deploy when they are preparing to challenge constitutionality itself. Tonight, sources confirm that the administration launched enforcement actions on 5 distinct visa categories, including the EB-5 investor visa program that had recently been expanded for what analysts believe was economic stimulus purposes. The government acted before immigrant communities could mount organized resistance. They hit the H-1B visa renewal process. They hit the green card interview waiver program. They hit adjustment of status applicants that were likely preparing to complete their permanent residency. In other words, the government targeted the infrastructure of legal immigration itself, the processing mechanisms that would have allowed millions to maintain lawful status. This is what made the AILA's warning so urgent. The government's move wasn't just symbolic, it was actionable. It represented the kind of policy shift that could destabilize millions of lives if left unchecked. And immigrant advocacy groups, understanding that fully, responded with force. Not recklessly, not impulsively, but strategically. They didn't file frivolous lawsuits. They didn't organize chaotic protests. They hit procedural due process violations. They hit Administrative Procedure Act requirements. And here's where the story becomes even more alarming. Sources now believe that the government's latest move was designed to test the resilience of immigrant communities after years of policy fatigue. The administration wanted to see whether immigrants would quietly comply. But instead, the opposite happened. Attorneys and advocates didn't retreat. They mobilized a response that was so swift, so coordinated, that even administration officials noticed. You don't get this administration's attention easily. But today, immigrant communities did. Immigration policy analysts, speaking with media under anonymity, described the government's shift as strategic exhaustion, a way to overwhelm immigrant populations with constant rule changes until resistance becomes impossible. But immigrants proved today that they remain both vigilant and unified. Their responses were not only rapid, they were targeted so precisely that multiple temporary restraining orders were filed within 48 hours. That timing matters because it shows that immigrant communities are not simply reacting. It shows that they are not passive victims. They are active participants in defending their rights. As reports continued coming in throughout the week, we learned more about the scale of the government's changes. Rule 1. USCIS carried out immediate termination of interview waivers, forcing millions to reschedule already approved appointments. Rule 2. The State Department targeted visa holders that had been granted extensions in the last 18 months. Rule 3. Immigration judges operating in backlogged courts reportedly received new guidelines used by the administration to expedite removal proceedings. Rule 4. Work authorization processing times were extended by 90 to 180 days. Rule 5. Green card holders traveling abroad now face enhanced re-entry scrutiny. This wasn't just administrative adjustment. This wasn't just routine policy update. This was systematic restructuring. This was comprehensive enforcement expansion. And comprehensive enforcement expansion is the one thing immigrant communities have struggled to combat since 2017. For every legal victory they have achieved, the administration has countered with something that complicates their status further. Remember, the administration thought immigrant communities were too fragmented to organize. They thought legal immigration advocates lacked the resources for sustained resistance. They thought years of uncertainty had broken the will of those still in the system. But tonight, the exact opposite is happening. Immigrant advocacy organizations are more unified than ever. Legal resources are being pooled across state lines, and the will of those fighting for their American dream has never been stronger. What makes this moment so critical and so dangerous is that the government's latest move happened at a time when the administration is under enormous political pressure. Hardline factions want faster deportations. Business groups want stable work visa programs. Courts want clarity on constantly changing rules. And voters want an immigration system that actually functions. The administration is balancing these demands while facing an election cycle that has made immigration the defining issue. And when leaders in that position make sudden moves, they're not doing it from strength. They're doing it from pressure. They're doing it from vulnerability. The State Department's statement, now circulating through immigration law networks, was designed to signal that the government is not willing to tolerate legal challenges to its authority. Officials said plainly that immigrant advocates' resistance was inconsistent with respect for lawful process. That is diplomatic language for, "We will not be stopped by courts or protests." You don't usually hear that tone from the State Department unless something serious is at stake. Meanwhile, the leading immigration advocacy coalition spokesperson addressed immigrant communities in a direct, emotional speech tonight. She said, "These rules target people who have done everything right." She said, Families who have waited years, sometimes decades, are being told their patience means nothing. And she said, "We will not accept the systematic dismantling of legal immigration." These are not rhetorical flourishes. These are statements from an organization that understands just how high the stakes have become. Here's what makes the situation even more concerning. The government's latest move wasn't isolated. Along with the 5 major rule changes, ICE also expanded interior enforcement priorities. CBP increased scrutiny at ports of entry for returning residents. USCIS dramatically increased denials for employment-based applications. All of this happened within the same 2-week period. When an administration moves multiple pieces at once, it means something larger is underway. Analysts are now considering several possibilities. One is that the administration is preparing a comprehensive enforcement surge before the election. Another is that the government is attempting to force self-deportation through bureaucratic impossibility. A third possibility, the one worrying officials the most, is that the administration is attempting to fundamentally redefine who qualifies for permanent residency in America. But today, immigrant communities took that card off the table. They didn't accept the changes quietly. They didn't wait for someone else to fight. They didn't assume the courts would eventually intervene. They organized, filed, and resisted within hours. What we're watching now is a test of constitutional limits. The administration wants to see how far executive authority can stretch. Immigrant communities want to show that legal residents have enforceable rights. Federal courts want to prevent administrative overreach. And Congress wants to prevent a constitutional crisis over immigration. Tonight, we've heard from immigration attorneys who are now tracking case-by-case impacts. They say denial rates have spiked 40% in some categories. They say processing times have doubled for work authorizations. And they say the government's decision to eliminate interview waivers is likely part of a broader strategy intended to create backlogs so severe that immigrants abandon their cases entirely. But immigrant communities are not surrendering. In fact, they are accelerating their legal responses. Their response today, coordinated, strategic, and unwavering, sent a message to the administration that immigrant communities will not be erased quietly. And it sent a message to courts that judicial intervention is desperately needed. As the coming weeks unfold, we expect more details to emerge about what exactly the administration hoped to achieve. But what we do know is that the advocacy community's response was timely. It exposed procedural violations, it created federal court records, and it unified immigrant communities across all visa categories. What happens next will depend on what the administration does in the next 30 days. If they retreat on implementation, this moment will be remembered as the turning point when immigrant resistance became undeniable. If they double down on enforcement, advocacy groups have already shown they are fully prepared for prolonged legal battle. They have shown they are ready to respond. And tonight, for the first time in years, the administration appears to be reconsidering. The White House is quiet. Too quiet. And when this administration is quiet, it means they are calculating. It means they are choosing their next move carefully. Because tonight, the government learned something they have learned many times before. Immigrants in America do not break easily. Legal residents have constitutional protections. And the American dream, no matter how many rules they change, cannot be revoked by executive action alone. This story is far from over. But tonight, one thing is clear. 5 rules changed, but 5 million voices rose in response. Green cards may be under attack, but the fight for them has only begun. And America is watching to see what happens next. And we will be here, watching every detail as the next phase unfolds.